Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you, Ms. Williamson. Good morning. Just as a matter of introduction, my name is John Bailey. I'm the Chief Justice of the court. I'm joined today by two distinguished jurists. One would be, ordinarily would be sitting to my right if we were in the actual courtroom, would be our Senior Chief Justice, Jim Arwright, my predecessor. I will let you know that on December the 7th, he will mark his 41st anniversary of being a judge. You can only do that by being very young when you become a district judge like he was. The one that would be to my left today would be Judge Stacy Trotter, who is a district court judge from Ector County, who will soon be joining our court as one of the justices on the court. He has agreed to pitch in and help us today under an appointment from Nathan Hecht to serve on our court during this transitional period. Before we begin, I would like to express our sympathies and condolences for Mr. McElroy passing away during the pendency of this case. We were originally scheduled to have arguments in April, and I know he reached out to let the court know he was going to have some health care issues, and I happened to notice that he did pass away, and I assume, Ms. Peters, that's the reason why you're joining us today for his place. But that brings us up to a question before I begin. How are you and Mr. Wetzel going to handle the argument today?
Your Honor, this is Rod Wetzel.
Yes, sir.
I was going to open on the statute of frauds issue for 5 or 6 minutes and then delegate the remainder of our time to Ms. Peters.
Okay.
Remaining issues.
We'll have a clock running, and I'll just tell you, y'all keep up with the time yourselves. It's too big. This Zoom business is hard enough as it is. So we won't allocate the time individually. It's just 20 minutes for the appellees to present their argument. So with those introductions and having that clarified, we'll now move on and call the case 11-1948 CV MEI Camp Springs versus Clearfork and Gunn Oil. Mr. Walcott, are you ready to proceed for the appellant?
Yes, Your Honor, I am.
You may.
May it please the court. I'm Matthew Walcott here from Freeman Mills on behalf of the appellant MEI Camp Springs, LLC. This is a case in which the plaintiffs' appellees obtained a judgment that they have title to an oil and gas lease without ever presenting the oil and gas lease. There are two overarching issues in the case. First, can a plaintiff seeking title and possession to an oil and gas leasehold estate obtain a judgment without ever presenting an oil and gas lease or directing the court to its oil and gas lease? In other words, can a court rule that there is a valid and subsisting oil and gas lease without ever seeing the lease? If the answer to that issue is no, that ends the analysis. We don't have to go through the rest of the issues. But if we do, we get into the second overarching issue, which is the statute of frauds issue, which is, can a purported lease, which is facially void for missing legal descriptions, have those legal descriptions supplemented to it by extrinsic documents that the lease does not refer to and that did not exist at the time the lease was entered? I'm going to go through a brief factual background and then address how the court should handle this the dueling summary judgment motions that were pending before the district court. So in January 2012, a memorandum of lease was recorded between Gunn Oil Company and Howard and Judy Gordon. That memorandum of lease was filed in the Fisher County records. It states that there is an oil and gas lease that was dated September 28th, 2011, about 4 months prior to the execution of the memorandum. And the memorandum identifies 12 tracts totaling 2,898 acres and change. The memorandum states that it's being put of record to provide notice of the lease, and that the original lease is maintained in Gunn's offices. In 2017 and 2018, MEI obtained its 2 top leases from the Gordons. Those top leases covered a total of 9 tracts, which are some of the tracts that are in the memorandum of lease. When Gunn filed this suit, it was about 3 months between the time that suit was filed and summary judgment was granted. And Gunn's claim was that it had leasehold title to the 12 tracts in 2,898 mineral acres by virtue of 3 instruments: the memorandum of lease, an amendment to that memorandum, and a purported amendment to a lease that was executed in 2015. All of those documents collectively Gunn refers to as the Gordon lease as amended. But it's important not to let that defined term obfuscate the fact that none of those documents is actually an oil and gas lease, and that Gunn never took the position that the actual lease was one of the documents that it was relying on as to get title, or to be defined as part of its lease or Gordon lease as amended. All of those documents also identify the 12 tracts and the 2,898 acres. So, as I said, there were dueling motions for summary judgment. How to navigate those, I want to take the Gunn's motion first, which was a traditional motion for summary judgment, seeking a declaration that it has title. And then I'll address MEI's no evidence motion, and then finally MEI's traditional motion, which is the statute of frauds issue. So taking Gunn's motion first, should that motion have been granted? No, it didn't carry its burden. Gunn's claim was a trespass to try title claim. It was pleaded as a declaratory judgment claim. This is a separate issue on appeal, but I think the courts have been very clear in this state that when you're seeking title to a possessory oil and gas interest, like an interest in a leasehold estate, the way to adjudicate title is the trespass to try title cause of action. So regardless of how it was pleaded, it should be treated as a trespass to try title case. MEI objected to Gunn's, and I say Gunn, and I should have clarified that I collectively refer to Gunn and Clearfork, or Gunn and Clearfork as Gunn. MEI objected to their leasehold title evidence because the 3 documents under the best evidence rule are not evidence of their lease. They don't, they all refer to a lease, they say a lease exists, but none of them is a lease. We cited the Ramsey versus Jones case out of Beaumont, and that case held that in trespass to try title actions, Rule 1002 of the Texas Rules of Evidence requires that if documentary evidence exists as to title to real property, that such documentary evidence must be produced and admitted. That's especially important here because, again, to prove under the best evidence rules, to prove the existence and contents of a writing requires an original of the writing itself. And here they were claiming that they had leasehold title. The lease is the instrument that grants them leasehold title. And especially here, where in 2018, they filed a lawsuit claiming title to 12 tracts, nearly 3,000 acres under a supposed 2011 oil and gas lease that had a 3-year primary term. We need the lease not just to identify the tracts that it covered, but to know what the terms of the lease are, to determine if in fact those 12 tracts are still covered by the lease. So the court overruled MEI's best evidence objection and granted the motion. In its appellee's brief here, Gunn claims that it didn't need to present the actual oil and gas lease that it was claiming title under. And it cites a single case, the Orca Assets versus Burlington Resources case. Orca is distinguishable. It's not on point with these facts. It didn't involve the best evidence issue at all. Briefly, in Orca, The issue was whether Orca Assets could claim bona fide purchaser status under a letter of intent. There had been a recorded memorandum of lease in favor of a company named Geo Southern. There was no dispute that as to what that lease covered. There was no dispute as to the fact that Orca did not have notice of it. The existence and contents of it weren't in dispute. And here, we contrast that with this case. Gunn filed a suit claiming title to a leasehold estate. So Gunn put its oil and gas lease, the existence of it and its contents, in dispute. Even if it didn't, MEI certainly did when it objected under the best evidence rule.
Mr. Walcott,
Yes, Judge.
is it of any consequence that the top lease makes reference to the memorandum and says that it's currently that the property is currently under lease by that memorandum of 11 or 12, whatever date it was?
I think that may be of consequence when we get into the vesting of MEI's title. But under their perpetuities claim, MEI's lease is vested. If the court were to consider the validity of their underlying of whether the unauthenticated lease was actually a valid lease, it would have vested immediately upon execution. But certainly, I think when we look at that issue, we take a holistic approach to the intent of MEI's top lease, which is to not cloud title, but to have a lease that vests upon a determination that Gunn doesn't have a lease.
Well, and that was the purpose of my question, is could that be considered an acknowledgement that that lease exists if it's cited in the top lease? The previous, I saw, I think the Supreme Court called it the bottom lease.
I call it the bottom lease too. Sometimes, importantly, the top lease actually refers to the memorandum of lease because Gunn wasn't, aware of at the time. I don't believe they had, they couldn't describe the actual lease. So it's only referring to the memorandum of lease on that issue. But again, the vesting of MEI's top lease, I think, it should be treated as any other lease, and that really wasn't an issue that was presented here of how that would affect the evidentiary issue of whether they carried their burden. Continuing on to the evidence issue, I would just point out that I would like the court to take a look at the Mercer case and also this court's own opinion in Grijeco, which I'm probably mispronouncing, and contrast that with Orca Assets, because those cases actually dealt with best evidence rule. And the Supreme Court in the Mercer case held that a copy of a promissory note could not be used in place of the original when the original wasn't presented. And in this case, we're even a step removed from that, because not only did Gunn never present the original, didn't try to present a copy or anything else. And then in this court, in the Grijeco case, was actually dealing with an affidavit that explained the absence of the original lease, because the only copy of the lease that was in the record was supposedly a copy of the original, but it was illegible. And the court distinguished Mercer on this basis because they had an affidavit that explained why they couldn't use the original lease. Here, Gunn offered no explanation for why it couldn't produce its own lease. The memorandum says that its lease is in its possession. There was no affidavit, no testimony or evidence of any kind as to why it couldn't produce its own lease. On appeal, Gunn also argues that the trial court could have considered this unauthenticated lease attached to MEI's traditional motion as evidence of Gunn's leasehold title. That lease was a document that was given to MEI's landman by the lessor. It did not come from Gunn's possession. And it of course contained no legal descriptions, but it states that it covers 3,665.013 unidentified acres. MEI was not producing this lease saying this is Gunn's lease. It brought that into the evidence saying if this is the lease, that Gunn is claiming title under, in which this is the only lease that MEI is aware of that they make it claim title under, it has these problems with it under the statute of frauds. But importantly, MEI couldn't authenticate that lease. Only Gunn can authenticate the lease that it's claiming to be its own lease. And Gunn even questioned the authenticity of that lease. They state in their appellee's brief at page 8 that it didn't contain legal descriptions, so it's not the lease. Of course, there's no evidence that supports that one way or the other. The fact that it was on file at the time of the summary judgment ruling doesn't apply because Gunn still has to direct the court to any evidence on file that it wants to use in support of summary judgment. This was not even on file when it moved for summary judgment, and they never directed the court to it. And the court's order doesn't say that it was considered. So, because they didn't carry the burden, Gunn's motion should have been denied. Moving to MEI's no evidence motion, for the same reasons largely that Gunn didn't carry its own burden on its traditional motion, MEI's no evidence motion should have been granted because in response to MEI's no evidence motion, it asserted the same grounds for its title claim, that the 3 subsequent documents give it title to an oil and gas lease. Now, I want to just hit on a couple of nuances under the no evidence practice and the practice when you file a combined motion. First, the court should consider the no evidence grounds of MEI's combined no evidence and traditional motion first. And the court's required to ignore evidence that is attached in support of the traditional motion unless the non-movement Gunn specifically directs the court to it. And we've cited a Dyer case out of Fort Worth Court of Appeals, which does a very good analysis on the reasons for that rule. So because Gunn failed to present any evidence of competent leasehold title in response, they take nothing on their trespass to try title claim, and that means that title vests automatically in MEI. Finally, okay, so moving into MEI's traditional summary judgment motion, this is the statute of frauds grounds. Now, MEI had attached a copy of this lease, its stamped copy, and it was obtained from the lessor by their landman, and it says that it describes, or it doesn't describe any acreage. It just says that there are 3,665.013 acres covered that are in an existing or in Exhibit A, but there's no Exhibit A. It's missing. It doesn't identify any tracts. We don't know if the 3,665 acres is one large tract, 5 tracts, or 1,000 tracts. Gunn doesn't dispute the fundamentals under the statute of frauds here, that the law is that you cannot supply a missing legal description to a document from an extrinsic document that was not referred to in the original. Instead, they rely on a narrow exception under the Reserve versus Hodge case, which is where it's a narrow exception where a void instrument is ratified after the reason that its void has been removed. So in Hodge, the operative fact was that the mineral deeds at issue there were cured of their invalidity before they were before the act of ratification occurred. And the court held that because they contained no description of the land, the 2 mineral deeds when delivered were inoperative. But according to our decisions, they were not so wholly void that they could not thereafter be made operative and effective by the insertion, if authorized by the grantors, of a correct description of the land intended to be conveyed. They did not hold that they could be made operative by the execution of a subsequent instrument that can be used to supply the missing description into the original document. And so if Gunn wants Reserve to apply, it really needs the facts here to be different But here, the reason for the invalidity was never removed. Separate statute of frauds grounds also is that the three subsequent instruments don't connect to this unauthenticated lease. Under the Douglas case, if the subsequent documents are amending a prior document, they have to identify that document or refer to the same subject matter. And it's not enough if they just identify the same parties or even the same date, because we have no way of knowing if the subject matter is the same. We don't know what the land was that was intended to be covered by this copy of an unauthenticated lease. We do know that it says 3,665.013 unidentified acres, but it would take extrinsic evidence to establish that the 2,898.933 acres in the subsequent documents are actually referring to the same acreage and were intended to refer to the same lease. I'll briefly, there was a perpetuities defense raised. That was an unpleaded affirmative defense challenging the enforceability of MEI's top leases. And it should, therefore, because the MEI objected, it shouldn't have been a basis for summary judgment. Further, the claim is without merit under the Ladix case. Unless the court has any questions about that, I'll rely on the briefing to address that issue. And the last point was that we had raised an alternative grounds for continuance. This applies only to Gunn's motion for summary judgment. Gunn's motion should have been denied on legal grounds, but when the court did not deny it, it was an abuse of discretion to not continue it, to allow MEI to conduct discovery on its affirmative defenses to this ratification theory that could have barred the ratification theory. So again, we'll rely on our briefing unless the court would like me to elaborate. But in summary, we're just asking the court to apply bedrock principles of evidence, summary judgment practice, and conveyancing to this case. A plaintiff seeking determination of title, superior title to leasehold property, must present evidence consisting of the actual original lease. Gunn failed to do that, both in support of its own motion and in response to MEI's no evidence motion. They should take nothing on their trespass to try title claim, and MEI should be vested with title. Second, even under the authenticated lease, which Gunn never relied on, that can't be used as evidence of leasehold title under the statute of frauds. That's not a ratification argument, it's a supplying argument. Thank you.
Thank you, Mr. Walcott. Mr. Wetzel, are you ready?
Yes, sir. May it
Please
please.
proceed.
Thank you, Your Honor. As you know, I'm Rod Wetzel from Sweetwater, going on 43 years practice. Well, hard to believe. Actually been coming to this court for many, many years. Also, I'm an adjunct professor at Texas Tech Law School, where I've been for 2 years. Prior to that, I was at UT for 7 years. Mrs. Peters is with Mike McElroy's firm in Austin, and she actually prepared the brief in this case. And I'm going to defer procedural issues that have been discussed in the appellant's argument to her, and direct my focus for 5 or 6 minutes on the statute of frauds issues in this case, and then she'll address the remaining issues. I'll begin by pointing out that in the last 43 years of my practice, mentors that I've had, like Charles Griggs, that you may remember, a lawyer from Sweetwater, later Ernest Smith, always had a saying that beware of the lawyer with only one case in his or her briefcase. And as far as the statute of frauds in this case is concerned, I think that case is a quite old case. Maybe not old as far as I'm concerned, but old for others. A 1948 Supreme Court case in Reserve versus Hodge. I know the court has read that case, so I will not belabor the facts, but I would like to simply point out quickly that the facts of that case involve 2 mineral deeds in which, for whatever reason, the exhibits of the property descriptions were omitted. And someone, it was not the grantors, they later admitted, someone attached those exhibits to the deeds before they were recorded. But I think the critical issue was the court found that some years later, the grantor and grantees and those documents all joined together in an oil and gas lease, which formally recognized the validity of the prior mineral deeds. And therefore, as the court says, although they were originally inoperative, they were not so wholly void that they couldn't be made operative and effective if authorized by the grantors. And I think that language is very important, particularly here, authorized by the grantors, to include a correct description, because that's exactly what happened here no less than 4 times after the original document was signed on September 28, 2011, and before the top leases were given to MEI in 2017. I've done extensive research on this issue. I wrote an article on statute of frauds in 2014 in my mineral titles class. It's an important part of our discussion because of the harshness of the rule. And also, again, this summer, I've written another article to be published by the Texas Tech Law Review with one of my associates, Laura Bowen. And that we found that this case has not been, of course, overruled or even seriously challenged or modified in the last 70 years. Just some quick facts that I'd like to point out on this case that I think are critical. And that is, there was an oil and gas lease on September 28, 2011, which for whatever reason, and it was disputed whether or not there was an exhibit. But for purposes of appeal, taking the assumption there was not an exhibit, a couple of months later, 3 or 4 months later, in January of 2012, there was a memorandum of that lease. It was executed by all the parties. And if you read that memorandum, it not only contains a description of the property covered, it also specifically incorporates the September 28, 2011 lease into it. And it also includes words of grant. So an alternate argument, of course, could be it could stand on its own as a conveyance if that argument were made. But in any event, that memorandum described the property. Now it has been brought up, the original lease recited some 3,600 acres, which wasn't described. And then later, the amendments and the memorandum talk about 2,800 acres. I think you have to look at the wording of the original lease more or less, commonly used by landmen who take whatever the lessor has. Later on examination, it may be that the lessor does not own all of the minerals. They think they do. I think the critical thing is what is described, and it was. Then it was later described again in an amendment of the lease in 2012 to amend the lease. It incorporated or referred back to the original lease in 2011, and it also included the legal description. Then it was amended again in 2015. That amendment that dealt with a continuous development provision also referred to the same property and also included words of grant. Those amending documents all were signed by all of the parties. This was not an issue where one party or another to the original document was trying to disavow it. So I would quickly point out to the court that many of these statute of frauds cases are one party or another to the original document seeking to disavow that document, not a third party coming along much later where all the parties are in agreement that the document is valid, trying to say it isn't. The last document was one admitted during the litigation, and that was an affidavit by Mr. and Mrs. Gordon that the original lease was valid. So we have no less than 4 ratifications expressly recognizing the validity and formal wording of the original lease. So we would submit to the court that reserve is very much in point. It is not a narrow holding, and that the court in reserve did not reach the issue of who attached the exhibit. So they did not need to reach that issue. So there's no after to it. It doesn't matter because the court didn't reach the issue of who attached the exhibit or why it was attached because of the signing of the later lease. Now, I would be so bold to say, I won't, again, my time's way over. I want to point out quickly, I think I can distinguish, or I could distinguish or deny the applicability of all the cases that the appellants have cited, but I won't take time to do that. One I might carefully point out is the Morrow case. That's a Supreme Court case from 1972. Know something about that case because it was tried by George Leonard, who was a Sweetwater lawyer, and David Stubbeman of Abilene. One thing about that, the Supreme Court, looking at the facts, said the parties knew exactly what it was that they were contracting to buy in Jones County, but they messed up on the survey. And in order to get the property description, they would need parole evidence, which they could not do. But the court sent it back on remand to try under reformation theory to keep it from being void. Well, if you take the position of the appellants here, it was automatically void. The court couldn't have remanded it to be reformed. So anyway, I just point out that one case. And I would also, again, point out the discrepancy. I would submit there's no credence about the discrepancy because the more or less language, there's very old cases in Texas on that language. Also, another matter to point out, the lease in itself in paragraph 32 says that the description will be contained in a memorandum that will be signed by all the parties, which did happen. Lastly, I guess it may be the professor in me, but I would like to make a quick policy argument, and that would be if you accept the argument made by the appellants here on statute of frauds, I think it'd be a recipe for legal chaos because it is a common problem that exhibits get shuffled around at closing and lost. Deeds get drawn up with omitted lines on meets and bounds and so forth. If those deeds or contracts or leases were automatically void, then we would be in a lot of trouble and we would have a lot of problems. So I would submit to you that the statute of frauds here has been satisfied by the amendments and the memo, and I will now turn over the remaining argument to my colleague.
Good morning, judges. I first wanted to start off with the summary judgment procedural issues. MEI's assertion that summary judgment could not have been granted to Gunn because Gunn did not submit a copy of the unrecorded lease has no basis in law. In fact, MEI didn't cite any cases stating that the only way to prove title under an oil and gas lease is to submit an unrecorded lease. That's just not the law. Gunn submitted the recorded memoranda and the amendments. It's standard practice under oil and gas law for the parties to want to keep the details of the lease confidential and to instead have a memoranda that is recorded instead. That is common practice. The Orca Assets versus Burlington case affirmed summary judgment on practically the same exact type of evidence. Memoranda of the recorded memoranda of the oil and gas leases. As far as the no evidence argument, Gunn responded to the argument, to the motion by incorporating its evidence. Gunn had already submitted its summary judgment and had submitted its summary judgment evidence. It was relying on the memoranda. Mr. Wetzel's correct. I drafted the brief, so I can say for a fact, contrary to what Mr. Wolfer has said, I did not question the authenticity of the lease, and I also did not argue that the court relied on MEI's unrecorded lease. I did not argue that. And I did argue that the court can consider all of the evidence, and that evidence includes the recorded memoranda. The cases that MEI cites for its no evidence position are cases where the respondent didn't provide any evidence at all, and they wanted to rely on the movement's evidence. And that did not happen here. The court properly granted summary judgment in favor of Gunn based on Gunn's evidence. So for those reasons, MEI's first and second issues submitted to the court should be overruled. I next wanted to talk about the rule against perpetuities. The top leases are void under the rule against perpetuities. Paragraph 14 of both top leases expressly state that they are only effective upon the termination of the Gunn leases. The top leases acknowledge the validity of the Gunn leases and expressly state they will only become effective upon the termination of the Gunn leases. In other words, the vesting of the top leases is contingent upon the termination of the Gunn leases. The Supreme Court in BP versus Maddox actually stated that an interest in oil and gas lease that is contingent on the expiration of an existing oil and gas lease violates the rule against perpetuities. The Supreme Court made a similar holding in the Pavito versus Starkey case, where there was a grant that was made effective only upon the expiration of Pavito's deed. The Supreme Court held that that grant also violated the rule against perpetuities. And these are rulings that are common to this case. In this case, the Gunn lease can be perpetuated as long as there's production on the land or on pooled lands. So as long as there's production, the Gunn lease is perpetuated. Now this can happen for more than a life in being plus 21 years. We've seen oil and gas leases that have been perpetuated for years and years and years. And that's why if you are entering into a top lease that is contingent on the perpetuation, that is contingent on the termination of an oil and gas lease, that it has a perpetual term, that's why it violates the rule against perpetuities. MEI.
Ms. Peters,
Yes, sir.
how do you respond to the argument that that the appellees didn't plead rule against perpetuities?
Yes, sir. The rule against perpetuities is not an affirmative defense in this case. An affirmative defense is an acceptance and avoidance. We're not claiming an acceptance and an avoidance. We're submitting the rule against perpetuities as a defense in denial. Gunn has raised the rule against the suit to quiet title counterclaim made by MEI, where they're claimed that their top leases are valid instruments. And our defense is that these are not valid instruments. Our defense is not to accept that and to try to avoid it. This is actual denial of those claims.
Thank you.
What's your question, sure? Yes, sir. So for MEI has also argued that the rule against perpetuities hasn't been applied or doesn't apply. That's also not true. The past 3 years, I counted about 5 or 6 rule against perpetuities cases that were applied, including Yowell versus Granite Operating Company. The Amarillo Court of Appeals in 2018 ruled that a reserved interest that is contingent upon the expiration of an underlying lease violates the rule against perpetuities. And that's what we have here. So for the issue, for the reasons asserted, MEI's third issue should be overruled. As far as the declaratory judgment, it's appropriate to seek declaratory judgment because Gunn is seeking a declaration concerning specific instruments. Lance versus Robinson covers those issues. And the act is used to resolve issues of construction and validity concerning an instrument. Both parties in this case have questioned the validity of each other's instruments. MEI's paragraph 26 in its answer questions the validity of Gunn's title, and Gunn also questions the validity of MEI's title as shown in our defense on statute of fraud, rule against perpetuities. The Supreme Court in Lance held that a party may pursue a claim under the act to prove that competing claimant owns no title. We are arguing that MEI owns no title. So for that reason, we believe that the fourth issue has no merit and should be overruled. Finally, as far as the continuance, it was appropriate for the court to deny the motion for continuance. MEI's motion states that there are no fact issues in this case, and Gunn agrees there are no fact issues in this case. This case involves the interpretation of unambiguous documents. The interpretation of unambiguous documents is a question of law for the court to decide, and parole evidence is inadmissible. So discovery to try to create a fact issue is inappropriate, and the trial court was proper in denying for that basis. So for those reasons, the fifth issue should be overruled.
And Ms. Peters, on that basis, is it your position that all of the documents that were to be interpreted by the trial court had been submitted?
Yes, Judge, that's correct. Any other questions? I tried to speed through that a little bit so I'd have some time left over for further questions. But in conclusion, the court got it right. The Gunn submitted valid memoranda of illegal oil and gas leases. That's standard practice in oil and gas law. We believe that MEI's issues have no merit and they should be overruled. And I'm available for further questions.
I don't believe there are any questions. Thank you very much for your argument. Mr. Walcott, you'll have 5 minutes for a rebuttal.
Thank you. To first address some of the issues raised by Mr. Wetzel, the memorandum, which is at page 38 of the clerk's record, does not contain granting language. It identifies the lease. It doesn't contain words of grant. And more importantly, again, we take a holistic view of what the intent of the document is in determining whether it's a conveyance instrument. And the express intent of the memorandum of lease was to just put people on notice that there is a lease. The lease is the conveyancing instrument. The amendment to the memorandum is at page 42 of the clerk's record. It did not purport to amend a lease. It amended the memorandum of lease. And it also purported to amend a separate memorandum of lease that was also apparently recorded but not put into the record. Gunn never raised an argument about paragraph 32 of the unauthenticated lease, making reference to an extrinsic document, but just to clarify the representation that it refers to a memorandum, it did not. It said the parties will simultaneously, with the execution of this lease, execute counterparts of an instrument in recordable form. It doesn't identify the instrument. It says that it's supposed to be executed simultaneously. And again, we don't know if these subsequent instruments even connect to the lease. We have no way of knowing what it's referring to. The more or less language, Gunn cited no case law that supports that you can use more or less language to fill in the gaps and make the logical leap that a document that says that it covers 12 tracts and 898.933 acres is covering the same property as a document that says that it covers 366.013 acres and doesn't describe any property. With respect to the Morrow case, when the court in Morrow remanded and allowed the proponent to retry its claim under a reformation theory. Again, first of all, they didn't plead reformation in this case, but the court noted that the evidence in the case and the record in the case supported a reformation claim. That was not the case here, though. They didn't plead reformation. They haven't argued reformation in their briefing, but reformation has a limitations problem for them. And most importantly, though, the pleadings here and the evidence that was on file do not support a reformation claim, because for reformation, you have to have mutual mistake. And there's no evidence of a mutual mistake. And I would also direct the court to the part of the Morrow opinion that says that there is no dispute between the parties about what the intent was, but then it says the intent doesn't matter. And I would also direct the court to the Wade versus XTO case out of the Fort Worth Court of Appeals. Again, the court went out of its way to discuss the fact that there was no disagreement between the parties of what the subjective intent was, but it's the intent in the document that matters. The idea that this is a recipe for chaos, that there's some kind of slippery slope, I think it'd be a greased mountainside going the other direction. And I'm not sure what the reference that Mr. Wetzel made to the CLE article he wrote, but he actually predicted a scenario in another CLE article that you could have statute of frauds problems when folks go out based nothing on more than maybe a tax roll number, and they get someone to sign a lease, but not knowing what they own. That is a recipe for extremely anti-competitive behavior in the oil and gas field. And it's not what the statute of frauds, it's exactly what the statute of frauds was meant to prevent. There was no confidentiality issue raised with respect to their lease. Briefly on the perpetuities argument, Gunn is ignoring the express reversionary grant language and the fact that the Lattice case relied on that. Lance itself, of the Supreme Court case of Lance, establishes that this was a trespass to tri-title case. Thank you.
Thank you very much, Mr. Walcott. I need everybody to stay with me for a second. Ms. Williamson will come back on and adjourn the court. That's for YouTube purposes. So with that, your case has been submitted, and Ms. Williamson will now close the court.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.